Do you think this is funny?
I'm allowed to laugh.
The arrested for laughing case. I'm the lawyer on that civil rights lawsuit, and just last night we got a ruling finally on whether or not that police officer gets qualified immunity. He got pulled over here in West Virginia for flashing his headlights at oncoming motorists in order to warn them of a notorious speed trap.
That guy flashing these lights, warning everybody you're sitting there. I'm going after him.
That wasn't a crime, so the officer basically made up a citation, and when he went to give it to my client, he laughed.
And I could take you to jail today for your unsigned registration card, but I just wrote you a citation for that. That's actually up to 6 months in jail. You think it's funny, sir?
The officer didn't like that. He pulls him out of the car. He ends up putting him in handcuffs.
Step out of the vehicle.
Are you serious?
Place your hands behind your back for me.
Are you serious?
Yes, sir. Place your hands behind your back for me.
Oh, man, you're serious, brother.
I'm not your brother.
I've seen on some of the viral videos floating around the internet all sorts of claims about what actually happened in that case. But they're all wrong. I'm litigating the lawsuit and it's actually still pending. But there's a huge update. After we filed the lawsuit, that officer and the sheriff of that county asked the federal court to dismiss it and to give the officer qualified immunity, claiming that the driver had no right to warn others about a speed trap and also had no right to laugh at the police. And the court answered those questions. Did he get qualified immunity, or did the court deny him qualified immunity? I recently realized that I had no idea how many subscriptions I had on different devices and had no idea how much those were costing me every month. And I was actually shocked to find out how much it was, at least once I was able to finally track them all down and add them all up. How great would it be if you just had an app that would keep track of all of that for you? That's why I love this video's sponsor, Rocket Money. Rocket Money is an all-in-one finance app that helps you save more and spend less. It helps you manage subscriptions, lower bills, build a custom budget, grow your savings all in one place. But my absolute favorite part of using Rocket Money is to cancel unwanted subscriptions. It securely identifies recurring charges and allows you to cancel these with just a few taps. You never even have to get on the phone. They do it for you, and they've helped customers save over $500 million in canceled subscriptions. So if you want to save more and spend less, go now and join the over 5 million members using Rocket Money. And here's what you do. Go to rocketmoney.com/civil or click the link in the description to get started for free. You can also unlock even more features with premium. That's rocketmoney.com/civil to get started for free. Thanks again to Rocket Money for sponsoring this video. Now let's get back to it. This video is about the actions of Nicholas County, West Virginia Deputy J.D. Ellison. The county seat of Nicholas County is Summersville, West Virginia. For many, many, many years, the 4-lane highway, Route 19, that runs through or next to Summersville has been known as a notorious speed trap. In fact, in footnote 1 of the court's order that I'm going to tell you about in this video, the court took judicial notice of the fact that this incident happened at the site of a notorious speed trap. I even found some news videos going way, way, way back discussing the fact that this spot is a speed trap.
Ever get a speeding ticket you didn't think you deserved? Well, this is a story for you. It's about Summersville, West Virginia, a town that likes life in the slow lane. So much so, it's known as the speed trap of North America, handing out thousands of tickets a year. For Canadians, there is one big bump on the road to a late winter respite in the U.S. South. And it's here, amid the rolling hills of the Appalachians, where the local law patrols its turf rigorously, assiduously, unrelentingly. Though they don't target Canadians specifically. No. They'll write speeding tickets to anyone passing through.
Hello, man. Have your operator's registration there? Okay.
Abandon hope, all ye who enter here. Here being an otherwise tranquil little community of 3,000 or so souls, nestled alongside a roadway very popular with thousands of Canadians traveling back and forth on Florida vacations.
At least back then, they apparently were much kinder, at least when they were on camera, to the Canadians than they were to William Iannacona, who was the guy that this happened to, who originally brought me the footage. William Iannacona was driving through this notorious speed trap, this stretch of U.S. Route 19, on May 13th of 2022. And while doing so, he noticed a parked police car that was running radar to catch speeding motorists. So he decided to send a warning to the oncoming motorists that they were about to cross paths with the officer. To send that message, he began flashing his headlights at the passing cars. As the court wrote, his message got through to the oncoming motorist, but unfortunately for him, Deputy J.D. Ellison was among the recipients of that message. Ellison, a deputy of the Nicholas County Sheriff's Department, turned his vehicle around and initiated a traffic stop. In his body cam footage, Ellison can be heard talking to another officer, presumably the one that was running the speed trap, notifying him that he caught the plaintiff doing this and that he was going to pull him over.
That guy flashing these lights, warning everybody you're sitting there. I'm going after him.
And after he did, Deputy Ellison explained to Mr. Iannacona that he had pulled him over for flashing his headlights to warn other drivers of the officer running radar.
That was pretty stupid, wasn't it?
What's that?
Flashing your lights at everybody to let them know that law enforcement was sitting there running radar.
Is that what I did? Is that a crime?
Yeah.
It is? I didn't know that.
You got your license registration proof?
Yeah, I did.
Why would you do that? You're flashing your high beams at people to...
In the daytime?
Yeah.
He admitted to the other officer why he did it. He admitted to Mr. Iannacona why he did it. That's really not in dispute. The driver then explained to the deputy that he was unaware that flashing his headlights as a warning to other drivers was illegal.
I didn't know that was a crime, sir.
It doesn't say daytime or nighttime. It just says that you can't do it, and you did it.
I didn't know that was...
Yeah, you can't high beam people at any time in the daytime or nighttime.
I didn't know that. I didn't know. I mean, nighttime I understand, but daytime I don't know.
I'm sure I could articulate some other kind of driving charge in there for doing that too. That's pretty crappy.
Yeah, I apologize for that.
And he said that he believed he was engaging in protected speech by using his headlights in this way. But as the court wrote, Deputy Ellison was unmoved by plaintiff's constitutional appeal. He proceeded to write out 2 citations to the plaintiff, one for violating the Special Restrictions on Lamps statute, whatever that is, and another for an unsigned registration card.
All right, sir, there's your stuff back there. And I wrote you 2 citations today. First one being Special Restrictions on Lamps, which you can read that code, and it says no flashing lights shall be on a vehicle. And at that point in time, you had flashing lights on your vehicle. It's unauthorized.
Well, under the Constitution, it's protected in the First Amendment. But I'm going to look into it.
That's in Tennessee.
Yeah, I'm going to look into it and
Yeah.
see about West Virginia.
Yeah.
'Cause it's free speech, you know.
Yeah, it's not illegal to do that, to flash and warn, but it's illegal to high beam. And it is legal to have flashing lights on your vehicle, not being an emergency vehicle.
I'll see.
Huh?
I said, I'll see.
Okay.
Before he gave the citations to the plaintiff, Deputy Ellison proceeded to extend the traffic stop. He began explaining to Mr. Iannacona that the maximum penalties for an unsigned registration card included 6 months in jail and that he could arrest him instead of giving him a citation. The driver, apparently finding this suggestion absurd, began laughing. That then infuriated Ellison, who immediately retaliated by ordering him to get out of the vehicle, and then he placed him in handcuffs and led him back to the cruiser. During this exchange, where Deputy Ellison took exception to being called brother by saying, "I'm not your brother, and I'll never be your brother."
And I could take you to jail today for your unsigned registration card, but I just wrote you a citation for that. That's actually up to 6 months in jail. You think it's funny, sir?
I'll take the ticket, sir.
I know, but do you think this
I'll
is
take
funny?
this. I'm allowed to laugh. I can laugh all I want.
Okay. Go ahead and step out here for me.
No, I didn't do anything.
Sir, I'm asking you to step out the...
Am I being detained?
Yes, sir, you are. Step out of the vehicle.
Are you serious?
Place your hands behind your back for
Are
me.
you serious?
Yes, sir. Place your hands behind your back for
Oh,
me.
man, you're serious, brother.
I'm not your brother.
Believe me, you're not.
Yeah, I'll never be your brother. I'll never be your brother.
Exactly. Be careful.
I don't want to
sir.
be your brother.
Be careful.
Don't jerk away from me, sir.
Just be careful.
Don't jerk away from me.
My wallet is in the car.
Okay, I don't want you to jerk away from me
I was
right
going
there.
away from the traffic.
No, I was putting you in front of my car,
Okay.
which is away from traffic.
You're arresting me for laughing.
No,
I didn't do anything.
I'm arresting you for unsigned registration.
Okay. All right. That's fine.
Okay? So stand right there. Hang tight in front of my vehicle for me. Hang tight right here in front of my vehicle for me.
The plaintiff was then forced to stay in handcuffs for several minutes along the busy Route 19 before eventually Deputy Ellison finally released him after speaking in his car with an unnamed prosecuting attorney.
I guess I'll see you in court. All right, ticket still stands there. Special restrictions on lamps, unsigned registration card. I gave you till the 23rd of this month to contact the magistrate. Phone number's on your copy there. Once you contact them, they can tell you how to take care of it.
Okay.
All righty, sir. Be safe.
He brought the original video to me. I helped him find a criminal defense attorney. I did an update video on it after he beat the criminal case on appeal, actually. Since then, I filed a federal civil rights lawsuit. That police officer asked the federal court to grant him qualified immunity, and the ruling just came out last night. By the way, this is what Deputy Ellison's boss, the elected sheriff of Nicholas County, West Virginia, this is what he had to say about the video that you just watched of what he did to Mr. Iannacona. He specifically addresses this video. So listen to what he says and then compare his words to the court's opinion.
Another topic I would like to cover is incidents regarding one of our other deputies, Deputy Ellison. There's been a live video circulating regarding a traffic stop that resulted in citations being issued. During the stop, the individual began laughing at said officer because of flashing lights and trying to warn other drivers of what could have been a high priority investigation. Examples: trying to locate a missing child that's been abducted, murder suspect, someone bringing poison, drugs into our area that possibly get into our child's hands, trying to find an offender running the stoplights. We all know that's a current problem in our area. When someone acts irrational, it is not normal and raises questions for further possible involvement in criminal activity. He was detained for a short period, then released with citations of what the officer believed was a violation. To further add to the prosecutor believed a violation also occurred, resulting in a hearing where a magistrate convicted and believed one occurred also. The case was then appealed to the circuit court before Judge Callahan, where he overturned the ruling. I will say I believe the wheels of justice was served. And this, folks, is exactly why we have the best justice system in the world. Nowhere else in the world has this type of accountability and freedom. It is not perfect. However, it is very rare that it fails the citizens of this country. I also say, as individuals, none of us are perfect. There was only one. Mistakes were made daily and addressed accordingly. As to the officer involved, he has received counseling not only from myself, but my chief and his immediate supervisor. Our office has the utmost respect for our prosecutors, magistrate, and judges. They do an outstanding job for our community. 100% behind them.
That was the sheriff's opinion, but here's the opinion that matters so far, and that's from the federal courts. As applied to these specific facts as alleged that I've just recited to you, the court held this. Plaintiff contends that Deputy Ellison stated he initiated the stop because plaintiff was signaling other drivers of the presence of another officer. There does not appear to be a law in West Virginia that criminalizes such behavior. Taking the facts as the court must in the light most favorable to the plaintiff, Deputy Ellison allegedly initiated the stop without reasonable suspicion. Such a stop would violate the Fourth Amendment. The court explained that unconstitutionally extending a stop by even a de minimis amount of time violates the Fourth Amendment. So even assuming a valid traffic stop exists, police officers cannot extend that stop any amount of time, or they violate the Fourth Amendment. The court said by failing to hand over the already written citations and prolonging the encounter, Deputy Ellison arguably made the stop longer than necessary to effectuate its purpose. Regarding the fact that Ellison ordered Mr. Iannacona out of the car, the court said, while it is true that an officer may order a suspect out of the car during a valid Terry stop, such order is only valid if an officer possesses an articulable and objectively reasonable belief that the suspect is potentially dangerous. The defendants cite nothing to suggest that between initiating the traffic stop and plaintiff's laughter, that Ellison noticed anything that would suggest the encounter became dangerous to him. Without such justification, the act of ordering plaintiff out of the car is arguably unjustified. And regarding the frisk of the plaintiff, the court said, again, there is nothing to suggest at this time that Deputy Ellison became aware of an evolving threat to his safety. Thus, even assuming this was a frisk of the plaintiff, it was arguably unjustified based on the facts alleged. So I've told you many times that police officers forget that element. In order to pull somebody out of their car and frisk them, there has to be facts objectively available that the individual is armed or dangerous. And in many cases, that does not exist. Just like here. In many cases, that's used as sort of a retaliation for perceived disrespect. The defendants argued that there's no First Amendment right to flash your headlights and warn oncoming motorists about a speed trap. Here's what the court said about that. Given the fact that plaintiff contends that Deputy Ellison knew and understood the message he was attempting to send, the court finds no reason to conclude that flashing one's headlights do not constitute protected speech. Moreover, initiating a traffic stop because of protected speech and without probable cause would certainly deter a person from engaging in that protected speech in the future. Regarding qualified immunity, the court said this. Defendants assert that Deputy Ellison is entitled to qualified immunity because it is debatable and thus not clearly established that flashing one's headlights to warn other motorists is protected speech. That assertion, however, misses the point. Every reasonable officer in the United States is aware that retaliation for First Amendment speech is a violation of a person's constitutional rights. Whereas here, the allegation is that a defendant knew of the speech and reacted to it accordingly, qualified immunity cannot serve as a proper shield. If just as plaintiff alleges, Deputy Ellison knew of plaintiff's speech, had no probable cause to initiate the stop, and stopped plaintiff anyway because of that speech, then the actions make out a classic First Amendment retaliation claim. Thus, the court denied qualified immunity to Deputy Ellison. Also, the court said qualified immunity is not applicable to the officer's decision to order Mr. Iannacona out of the car and handcuff him, because it's clearly established that an officer may not arrest an individual either absent probable cause or with sufficiently provable retaliatory animus. In other words, police officers are supposed to know they can't arrest people just for their engaging in protected speech like flashing headlights. So there you have it. Like you heard in the sheriff's video where he tried to gaslight the public and claim that there was some legitimate public safety threat because this man flashed his headlights. He knows the real reason that Mr. Iannacona was stopped. Everyone knows the real reason. And the fact is that flashing headlights, whether the Supreme Court has recognized it yet or not, is a physical act among many, many others that are described by case law that can be protected speech. And in this case, as we've alleged, it was intended as protected speech, and it was received by the officer as protected speech, and he admitted that several times during the body cam footage. And that protected speech made him mad, so he retaliated. So this is just the motion to dismiss stage, which is based on the allegations made in the complaint. The court will address all of these issues again at the summary judgment stage, which will include the testimony of the individuals and all other evidence, including the video footage. We're still in the discovery process. That's still happening, but I anticipate the facts will show as we've alleged because it's all on video. It doesn't really matter if anyone disagrees with that. Therefore, no matter what you've seen on any viral video, this is a pending case. These things take time. Sometimes it can take years. Depositions are actually coming up in this case, and then we'll go to court again. And after we get a court order at that point, I'll hopefully give you a positive update at that time. So if you want to follow along, please subscribe both here and at the blog at thecivilrightslawyer.com. You can also follow me on X at John Bryant ESQ. Remember, our rights don't end where your fear begins. Freedom is scary. deal with it.